surprise me.
Hi, I'm Attorney Iworski. How are you?
Good, how you doing?
Good. So I'm covering for Attorney DeCroce today. So you're scheduled for a sentencing hearing today on the disorderly conduct, and then you were scheduled for a trial on the breach of bail charge, right? Is that what you have as well? Okay. So what we're going to do today is we're just going to go forward with the sentencing hearing. I'm not going to go forward on the breach of bail. You were convicted on the disorderly conduct. I don't see a reason to pile additional charges onto you. So you'll be sentenced on the disorderly conduct, and then we'll be done today. Okay?
So you're dropping the breach of bail?
I am. Yep. Okay. And I spoke with the trooper about it, and he's fine with that.
Good,
Okay.
Good. Thank you so much.
All right. Sound good?
Yeah, no problem.
All right.
All set?
Yep.
If there was ever a strong argument for the Second Amendment, it's the fact that we've got sovereign citizens wandering around insisting laws don't apply to them while openly carrying firearms. That combination alone is enough to make anyone appreciate the concept of responsible, law-abiding citizens being armed too.
Pretty dead, Frank.
Yeah, well, I mean, there's no way. I got the law right here, right? So I didn't create danger, obviously, which is why this has been dropped, and I didn't commit a felony, okay? I'm being persecuted for exercising my First Amendment rights.
The court is there to act as a neutral referee, not your lawyer, not your babysitter, and definitely not your personal assistant or trustee. Sovereign citizens push this nonsense because, in their fantasy version of the legal system, if a magistrate were somehow the trustee of one of their imaginary financial accounts, it would automatically create a conflict of interest. And if that were true, the magistrate would have to recuse herself. Then a new judge would be assigned, declared a trustee, recused again, and the cycle would continue until every judge in the state had been disqualified on paper to them. It sounds like a brilliant loophole, a clever way to crash the entire judicial system by forcing every judge to step aside. But in the real world, it collapses immediately because none of their underlying assumptions are true. Judges aren't trustees of your make-believe accounts. The courts don't owe you fiduciary duties, and their job isn't to manage your imaginary paperwork. Their only role is to apply the law, which is exactly why this tactic never works outside of sovereign citizen daydreams.
Great. How come you're getting angry? Didn't you and I just didn't we just have
Because I'm here today for nothing. That's why I'm getting angry.
You're here for a sentencing hearing.
Yeah, I know. And I got found guilty of disorderly conduct for less than what I'm doing right now.
Okay.
For being loud. Because I have a loud voice. So I got found guilty of disorderly conduct for having a disability because I get excited and hyper-aggressive.
All right, so that wraps up the officer's testimony. Pretty straightforward. He pulled the defendant over. The defendant was carrying a concealed handgun, and he failed to disclose that he had a CPL, a clear violation of MCL 28.425B, which requires you to immediately notify an officer if you're armed and licensed while being stopped. A competent lawyer could actually craft a real, legitimate legal strategy here. There are defenses that could be argued under the right circumstances. But instead of relying on someone who knows what they're doing, we get to witness how a pro-SE genius plans to talk his way out of it. So let's sit back and watch how an untrained defendant tries to out-lawyer an actual lawyer.
Okay. And you had your day in court.
Oh, and I was found guilty, yeah. I had my day in court, and what was I found guilty of? Why am I not under arrest for disorderly conduct right now?
Sir.
Why am I not under... Hey, listen, don't give me no directives. You're just going to make it worse. Ridiculous.
Hey, Frank.
Absolutely ridiculous.
Frank, was the breach of bail when they arrested you here? Was that one, or was it a different one?
Judge is on the way.
Yes.
We'll wrap this up and you'll be on your way.
That was the one, thank you. That was the breach of bail for the New Hampshire 9 arrest. For where someone was arrested for saying amen. And I was arrested for, we don't know yet, making a loud noise, which is all on video, and I didn't make one fucking peep. Not one fucking peep.
Yeah, well, we would know
Frank,
if you had.
you're in a courthouse.
I don't care. It's not illegal to swear. Okay?
If you
I don't need,
disturb
listen,
another
have me
person-
arrested. Do something. Do something.
I don't want to.
Do something, because you can't.
I'm trying to.
Don't give me directives and tell me what to do or what to say or anything.
Frank, come on, Frank.
Well, you were suspected of a crime. Illegal tint on your front windshield. Exactly as the officer explained. That's why the traffic stop happened in the first place. Now, I know you think you were pulled over because you're black. But you even admit later in this very video that your windshield did have tint on it. And if that's true, then let's use a little common sense. How was the officer supposed to know the color of your skin before the stop if your windshield was dark enough to violate Michigan law? You can't claim racial profiling when the officer literally couldn't see you to begin with.
I'm trying to, but these people, they all want to take their time. Oh, hey. Oh, just calm down. Let it be cool. No, this is absolute bullshit why I'm here today. And everybody knows it, and that's why you dropped those charges.
I told you why.
So I get it. You're cool. You dropped the charges. I appreciate that. It's nothing personal against you.
Then be
This
cool
is
to me
business.
like I'm being cool.
I am being as cool as I can be.
Frank.
Okay?
Come on, Frank.
You wanna get this done?
Oh, I'm ready. Let's do this thing. I've been here. Let's go.
The priest will enter.
All rise, honorable court is now in session.
All right, good morning, everyone. Thank you. Please be seated. All right, and this is State versus Frank Staples, docket number 435, 2021 CR 240, and dockets number 435, 2021 CR 1692. Attorney Jaworski does appear on behalf of the Newfields Police Department. She's filling in this morning for Attorney DeCroce. Mr. Staples does appear. He is self-represented. We are scheduled this morning for a sentencing hearing in the 2021 CR 240 on the Class B disorderly, and then additionally the matter is scheduled for trial in the breach of bail charge. Are we ready to proceed?
Judge, we're going to go forward on the sentencing order. As I told Mr. Staples, the state police are here. I had an opportunity to speak with them. Although we are ready for trial, I think in the interest of fairness and equity, he's been convicted of the underlying disorderly conduct charge, so we're going to use prosecutorial discretion.
How is it underlying when the breach of bail took place afterwards?
In that last segment, he somehow managed to deliver both a good argument and a bad argument at the same time. Let's start with the bad one. He absolutely should not have claimed that the legality of his actions depends on the officer's statement that the stop wasn't initially for window tint. First, he has no audio, no video, and no evidence to support that claim. Second, even if he did have proof, it wouldn't save him. He openly admitted that his front windshield had tint, and in Michigan, any percentage of tint on the front windshield is illegal. That alone establishes probable cause for the stop, no matter what the officer thought in the first 5 seconds. Now, the good argument he made, and yes, he actually had one, was pointing out that the officer didn't test the tint. That's a valid point, because he could have been bluffing when he admitted having tint. Without a measurement, minor tint-related citations could potentially fall through the cracks.
I'm going to not process the breach of bail charge, and we're just going to go forward on the sentencing hearing with the disorderly
Okay,
conduct.
all right, very good. And then I will give you that one. Oh, wrong one. I gave you that one. This is the breach.
That's somebody different.
All right, thank you.
Thank you.
All right, so with that then, if we're ready, we'll proceed with the sentencing and the state's recommendations. Mr. Staples, what I'm going to do is I'm going to hear from the state first, what they're recommending relative to the disorderly conduct, which was a Class B misdemeanor in that matter. And then after I hear from them, I'm certainly going to hear from you as to any recommendations or any position you take as to penalties, okay? So with that, thank you, Attorney Jaworski.
Judge, the city's going to ask for a $1,000 fine, 500 of that to be suspended for 2 years of good behavior. Your Honor heard the facts and circumstances of this case. This is an individual who has racked up similar charges to this recently.
That get dropped and dropped and dropped.
All right.
All right, that wraps up that video. And honestly, this is one of those rare cases where I'm actually pulling for the guy. He sounds young. He sounds like he's got at least a spark of intelligence left. And right now this country could use more young, capable people contributing something meaningful to society. Not drifting off into the window-licking world of sovereign citizen fantasyland. But hopeful moments are short-lived around here, because now we're moving on to our next case. This one takes us to Wisconsin, where another self-proclaimed sovereign expert learned the hard way that court dates aren't suggestions. They're mandatory. He decided showing up was optional, and the judge responded by revoking his bond on the spot. Now he gets to attend all future hearings from his brand new Crayon Taco Port, otherwise known as the county jail. So buckle up, because this next meltdown is exactly what happens when delusion, arrogance, and poor decision-making collide.
He has
Don't
a
interrupt them.
prior conviction for bail jumping in 2013, February 11th of 2013. It looks like he had 1 to 7 years for a sentence with counseling, mental health treatment. He had a possession of prescription drugs also in 2013 where he was convicted. He had multiple counts. He received a 12 months time served sentence in that particular matter. He had a possession of a controlled drug with intent to sell conviction in, looks like 2004 out of Hillsborough.
When is my sentence over? When is the crime done?
Yes, Mr. Staples, please, I'm gonna hear from you also.
Yeah.
But she gets to recount what she
Fine.
wants,
She
so,
can do whatever she wants.
thank you.
Another possession of controlled drug with a 9-month sentence. Shoplifting conviction in 97.
I was 17! A juvenile!
Mr. Staples,
So she's bringing up my juvenile record then?
Against your will, huh? Well, not exactly. You just admitted a previous judge asked you questions, and you chose not to answer them. That isn't oppression. That's contempt of court. And because you did it right in front of the judge, that's direct contempt, which is more than enough to justify a bond violation. In other words, this didn't happen to you. You caused it. You really should let the public defender speak on your behalf, because right now you are absolutely your own worst enemy. But in this matter,
I mean, come on! What's really going on here?
Staples, do I need to take a break? Let's just get through,
Let's get through it then!
telling me what she wants to recommend and about your
And
prior-
why? Because of all these past crimes all the way back to when I was 17?
All
Get
right.
the fuck out of
Stop.
here.
And please with the language. Attorney Jaworski.
Judge, he has a robbery conviction in 97 out of Hillsborough South with a 12-month suspended sentence. That's the first half of his criminal record. He does have an additional 6 pages, but I won't go through every detail with the court. But
actions have consequences. Play stupid games. Win predictable prizes. You keep saying you want to be out of jail and living your life, but every choice you've made has pushed you in the opposite direction. You fail to show up to your court dates. You refuse to answer basic questions from a judge. And once you were finally taken into custody, you had to be forced against your will to even participate in this hearing. At some point, we have to stop pretending this is bad luck or injustice. It's starting to sound like you're exactly where you need to be, because every decision you've made has put you right here. All right, that's the end of the video. If there are any updates, I'll keep you posted. If you liked the video, hit the like button. If you didn't hit dislike, engagement is engagement. Don't forget to leave a comment below and subscribe with notifications on so you never miss any of my content. And once again, a big thank you to Rakin for sponsoring today's video.
that's the reason why I am asking for a little bit of an enhanced fine, although I am asking that half of it be suspended for 2 years good behavior. Also, part of that good behavior is that...
Not paying shit. Believe that.
Okay.
Mr. Staples.
Sure we have the address. They cannot be allowed to respond to that same address when the disorderly conduct occurred, Judge.
Okay, Mr. Staples, you've heard the recommendation of a $1,000 fine with 500 of it suspended. Do you wish to be heard on what you're asking the court to impose within the limits of the maximum amount?
Yeah.
$1,200 fine.
$0. Also, I'm asking you to reconsider your finding of guilty because I will be appealing this. I'll put you on notice, and I do want to know exactly what did I do to commit disorderly conduct, because it was nothing even like what I've been here today in this courtroom. Okay? I didn't do anything that was disorderly. I asked why I was being threatened to be arrested. The man never asked me to leave the area. You've seen the video. He lied in his testimony. So I want to know why I was found guilty to begin with. What? You need to articulate yourself.
You wish to be heard on the sentence. We've had your opportunity.
$0. No penalty whatsoever.
Okay, thank you. And I've heard your testimony and listened for several hours at the trial, and I've issued that, and certainly you do have the right to appeal, and I will expect you to do that. So with that, I will adopt the state's recommendation and will impose a fine of $1,000. $500 of that will be suspended for a period of 2 years for your good behavior.
Put me in jail now then, $50 a day. Let's go. $50 a day in jail because I ain't paying shit.
It's 150 now.
So
150, whatever. We do $10 a day. Let's do it.
don't sell yourself short. Are you able to pay the $500 fine? I'm sorry, yeah, $500.
I ain't paying no $500 fine.
All right.
You gotta be kidding me.
So you know there is an additional time payment fee of $25 that gets added?
Don't care. I ain't paying none of it.
Okay.
Ever. Bunch of bullshit.
Probably have a bad day.
Huh?
Wish him a bad day.
You got it, yeah.
Amazing. You told her you weren't going to pay, and she's like, well, we'll put you on a time payment.
We'll put you on a time. Put me in jail now.
They don't want to put you in jail.
Let's go.
Put me in jail now. 5 years in solitary confinement. You get fucking fined. $500 fucking fine. Get the fuck out of here.
I love how they brought in
Unbelievable. You bring up all that fucking record too. I changed my life. I have a fucking business where I help people reintegrate from prison and from rehab and from homelessness.
You already know the answer to that, Frank.
Never.
Never.
Right?
Let's go. Come on.
We feel it right around. Bunch of bullshit. Hope you feel real good about yourself.
I don't think I've ever heard of anybody paying fines, any activists. It's funny, they think they get us and they don't.
Let's do it. I love this game. We could play this all goddamn day.
They just want to bring him back in for another hearing.
Yeah.
That's what they want.
Yeah.
Waste his time.